Watts. Welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and this is a very major change to the Fair Debt Collection Practices Act, specifically covering debt collectors, which would include eviction lawyers who are involved in evicting people due to non-payment of rent. And this is related to the CDC order. We've had a couple videos on this. Let me show you kind of the summary of this, and then it's a 69-page document. I'll put a link in the comments or the description, but then we'll jump down to the actual change in the law. And I think that this will be very, very interesting to you if you are renting and if you are potentially facing a possible eviction. So here's the summary. The CFPB is amending the FDCPA, or Regulation F of the FDCPA. And the interim final rule requires debt collectors provide written notice to certain consumers of their protections under the CDC eviction moratorium and prohibit or forbid misrepresentations about the consumer's eligibility or ineligibility for protection under that moratorium. It goes into effect May 3rd, so this is incredibly quick. Normally when there's a change, it'll be a year from now, 2 years from now. This just came out, so May 3rd. And let's see, we'll look a little bit at this summary, and then we'll drop down to basically about page 64 and look at a few pages there. So this is to address debt collector conduct related to this eviction moratorium with the CDC, Centers for Disease Control. And so we're looking at debt collectors as that's defined by the FDCPA. And generally, the FDCPA prohibits debt collectors from harassment, abuse, lying to you, or being unfair. So, just not very long ago, March 29, the CDC extended the agency order that imposes an eviction moratorium, and that pushes it out even further into June. But the CFPB is worried that consumers are not aware of that, and that debt collectors, particularly eviction lawyers, may be misrepresenting the truth to consumers. So it's going to require debt collectors, again, that would include an eviction lawyer, to provide written notice to certain consumers of their protections under the CDC Order's eviction moratorium, and to clarify that certain misrepresentations are prohibited. So let me just jump down. And again, if you're in this situation, you may be very interested to read all this. And it's very well put together, but we just don't have time to go through all of these pages. So let me get down to where we actually change the law here. And so this is the FDCPA, and this is just saying sort of what the authority is. And so what's the purpose here? So the purpose is to eliminate certain abusive debt collection practices by debt collectors related to COVID-19, and then to ensure debt collectors who refrain from doing that are not competitively disadvantaged. Okay, so let's just take those two things. They want to stop the abusive conduct by debt collectors, and they want the debt collectors that are following the law, that are being honorable, that are doing things the right way, not to be at a disadvantage, because otherwise the guys that are cheating and breaking the law have a competitive advantage, and we don't want that. So we have certain terms here. Consumer, debt collector, those are all the same definitions that we find at the beginning of the FDCPA, and that's 15 U.S.C. Section 1692A. Well, what is CDC order? Well, that's Centers for Disease Control, the temporary halt in residential evictions to prevent the further spread of COVID. So what does eviction notice mean? The earliest of any written notice that the laws of any state, locality, territory require to be provided to a consumer before an eviction action against a consumer may be filed. Now, some states you don't really have to do that, but most states you have to put maybe a notice on the door 7 days before you sue. And this is saying that's what we're talking about. Okay, so what are the prohibitions? So a debt collector, and so we're not talking about just a landlord, because they wouldn't be a debt collector, but when they hire somebody to do this for them, A debt collector must not, number one, file an eviction action for non-payment of rent. And we have other videos on this. You can be evicted for other reasons, but just not for failure to pay your rent. So a debt collector, including an eviction lawyer, must not file an eviction action for non-payment of rent to whom the CDC reasonably might apply without disclosing to that consumer clearly and conspicuously in writing that they may have some eligibility for help. And we'll look at that. They give us some sample. And they must not falsely represent or imply that the consumer is ineligible. So we see this a lot where maybe a collection lawyer, an eviction lawyer goes up to somebody and maybe they're at trial and the consumer says, well, I think I'm entitled to some protection under the CDC. The lawyer says, no, you're not eligible for that because, and then they just make something up. Well, I think that was clearly a violation even before this change. So I'm recording this on April the 19th. That's a violation right now. Anytime a debt collector lies about the law. So back in the day when the bankruptcy law changed, we'd had debt collectors telling consumers, you can't file bankruptcy anymore. They banned bankruptcy. Well, that's just a flat out lie. But here it's making it very, very clear that if you lie to a consumer about potential eligibility for this CDC protection, then that's going to be a big, big problem. And the CFPB had previously warned debt collectors, don't be messing with this. Don't take advantage of people. So now let's look at sort of the official interpretations. And so this is a vehicle by which they supplement Regulation F. And this is just telling us what the CFPB is thinking here. So here are some examples. Term eviction notice includes, for example, notices to quit, notices to pay rent or quit, notices to terminate tenancy. So every state may have it a little bit different, but the point is it's a notice that tells you you've got a problem because you're not paying your rent. And if you don't get caught up, then we're going to evict you. So here we go. Eviction action for non-payment of rent. So must not file an eviction action for non-payment of rent against a consumer to whom the order reasonably might apply without making the disclosure described in 106.9C1. So what does this mean about reasonably might apply? Well, it's a consumer who reasonably might be eligible to be a covered person as defined under the CDC. So again, we have to look at that order and see exactly what we're talking about there. So here's provision of disclosure. So on the date that the debt collector provides the consumer with an eviction notice, or if no eviction notice is required, on the date the eviction action is filed, you've got to tell that consumer that they may be eligible for temporary protection under the CDC order. So let's say in my state, they have to put a notice on the door 7 days before. Well, they got to tell you then. Maybe in your state, they don't have to give you any notice. They just sue you. Well, they better tell you with that lawsuit that in writing that you have this eligibility for temporary protection. So they give an example here. Delivering the disclosure to the address that's subject to the eviction proceedings. Okay. Let's see. A debt collector may provide the disclosure at the time they provide the consumer with an eviction notice or serves with the eviction lawsuit here. Now, they only have to do it one time. They can do it more than once, but only one. One time is required. So here's an example. It could be just a notice in writing. So we're not talking about text messages or verbal or anything like that. Because of the global COVID-19 pandemic, you may be eligible for temporary protection from eviction under federal law. Learn the steps you should take now. Visit cfpb.gov/eviction or call a housing counselor at this number. Or you could say, because of the global COVID-19 pandemic, you may be eligible for temporary protection from eviction under the laws of your state, territory, locality, or tribal area, or under federal law. Learn the steps you should take now. Visit cfpb.gov/eviction or call a housing counselor. Okay? And there's this idea of clear and conspicuous. So It's got to be clearly and conspicuously in writing. Well, what does that mean? Readily understandable. Location and type size also must be readily noticeable and legible. There's no minimum type size. The point is, you can't put in tiny little print at the bottom of a page. You've got to make it very, very obvious here. And if you do that as a debt collector, then the CFPB says you're not violating the law. But if you bury it or you put in tiny little print and it's not open and obvious or clear and conspicuous, then you may have violated the law doing this as a debt collector. So let's talk practical here. What does a CDC order require? Basically, if you can honestly say, I've been affected by COVID-19 and I'm doing the best I can paying, and if I lose this apartment, house, whatever, there's a good chance that I may end up being homeless or have to be in an unsafe situation. And if you put all that basically in an affidavit or you're swearing to it, then very likely you can get this protection, okay? And so these debt collectors have to tell you this, okay? If they don't, you may be able to sue the collector, sue the eviction lawyer. And definitely check out, if you're watching this video, check out the CDC, check out that order, and you can find it online. And it's very, very important that you look at that, because whatever your view is on COVID, I know, people have different views on this. What the CDC, and this started under Trump, is they said this is causing a problem when we're having people being kicked out of their apartments or their homes. Now, unfortunately, it doesn't apply for foreclosures, just evictions. But when they're kicked out, then they may go to a shelter or they may pile into a house with some family or friends, and then that may spread COVID even more, and it causes problems. So that's the authority of the CDC. And some people forget that this is Trump that started this, President Trump, and then Biden has continued it. And so, whether you love Trump or you hate Trump, you love Biden or you hate Biden, this has been pretty consistent through both of their presidencies, this CDC order. So it's here. A lot of these landlord groups are challenging this in court. Some judges are saying it doesn't stand up to sort of constitutional scrutiny. But overall, in most places, it's still the law. And obviously the CFPB thinks it's the law because they're telling these debt collectors, hey, you know what? You're going to break the law if you don't tell people about this. And again, this is 69 pages long. There's a lot of exceptions and things like that. But if you're in this situation, definitely, make sure you understand your rights. Read that CDC order. Again, this does not technically go into effect till May 3rd. But it does tell us that the CDC, that its order is something that the CFPB, Consumer Financial Protection Bureau, takes very seriously. And so if there are debt collectors that are lying about this, the CFPB is very, very interested in knowing about that. They may take action. And you, as a private citizen, can hire an attorney to sue that abusive debt collector and recover damages. Your attorney will be paid attorney's fees. You get damages. And so definitely make sure you understand your rights and exactly what you need to be doing. Okay, guys, thanks for watching this video, and I will catch you tomorrow. Bye-bye.